23.
Your Lordship.
That's fine.
Petition allowed.
To be spoken to item number 2, WBC 139 of 2025.
Standing counsel for the respondent authorities. So what is the actual amount yet to be recovered from the petitioner?
My Lord, the bank has debited a sum of rupees 17 lakhs, 11,737 as of now, my Lord.
What is the amount remains to be recovered?
My Lord, let me just check it out. My Lord, just give me 1 second. I'll just check it out.
Okay, can you inform the courtmaster before 12 o'clock today?
I'll give it to the court master, my Lord. If
Okay.
if it is the
Okay.
query of my Lord.
Okay. So tomorrow we will pronounce the judgment.
My Lord.
1 days.
1 day.
What are the charges?
And my lord, charges 22C, my lord, NDPS Act. Commercial
So
quantity, my lord,
it is submitted or not submitted?
not submitted, my lord.
Not submitted.
My lord, the whole case is based on the seizure list, search and seizure list, but there is the missing, the date and the Patharkanti PA GED number.
NDPS.
Both are missing. So, my lord,
Lordship, may I please to fix the date for CD, Your Lordship?
CD.
Yes. NDPS, commercial quantity. ma'am.
But 161 days, Sarcity is not submitted.
Lordship, that is his
I don't-
submission. Yes, we'll get the instruction.
my lord,
No, date of arrest you see 11/3/2026.
Yes. 26, 11/3.
my lord, on any condition, bail may be granted, my lord. I have.
No, FI is on
Apply-
11/3 to
Property.
2026. After some time, my colleague will take the instruction.
Okay, after some time.
I don't know.
Yeah.
Bail application, my lord, intermediate quantity, and my lord, as in today it is 18 days. CD may be called for, my lord.
18 days.
My lord.
Okay, CD on.
Lordship, after 10 days from Borpeta, my lord. Date due, na? 11/9.
No, sorted.
All right.
No, sorted. Last part.
It will be another.
28.
Lordship?
28.
28.
3.
May I be before Lordship? Lord, regular bail application, my lord, I am arrested on 13/7/26, my lord. FIR Lordship will see batch 18, my lord.
You are behind the bar for?
37 days behind the bar as on the day, my lord.
Let CD come, my lord.
My lord, the issue has been probed up, my lord. Between the
His certificate case.
yes,
That what is this? The trial is pending.
my lord, it's just sheeted only on 31st.
Certificate.
Yes, comments, my. My lord, this
Under which section search sheet is submitted?
charge sheet is same section, my lord.
Same section means?
Of my lord, section under section, my lord, 126 to
127B.
127 to 3, 3 within bracket 3, 351 3, and section 479 14 of which hunting act.
Which something?
Yes.
Now you come to
My-
the third page.
Third page, my lord.
Yes.
Yes.
This special judge NDPS Karbi Anglong. What is this?
Special judge, my lord. Session judge, special, not in DPS, my lord. It's, my lord, it is the same designation, my lord. It's a session judge, it's a special court, my lord.
Okay. Recessal call for the scan copy
My
of the
lord, my
record.
lord, if lordship permit me, my lord, this incident, in fact, very unfortunate, my lord. Incident had probe up between the informant, family members, and the villagers themselves, my lord. I'm neither the villager of that particular place. I'm different, my lord. In fact, my position as a priest, my lord, it's very unfortunate on my part, my lord. Maybe it's a bad day for me, my lord. Unfortunately, this, after some incident, this informant and some of his relative and some of his villagers, my lord, they have came in my temple, my lord. Therefore, my lord, as a priest, my lord, I have nothing to do with them, my lord. I have,
all right,
I have, my lord, admittedly, my lord, and
right.
permit me, my lord.
All right. Let the record come. We will appreciate your submission.
Lordship, kindly see there is a memorandum also I have annexed, my lord. What I did, my lord, is that, my lord, I fairly advised them, I have nothing to do,
Mr.
you
Mori,
please
you see.
settle the issue amicably. My lord,
Without-
thereafter, what happened, my lord?
No, Mr. Mori, you
Yes.
see, without perusing the record and the case diary, we cannot consider your
Lastly,
petition.
is there, my lord, I have subsequently procured, my lord.
Records come, your lordship.
Kindly, nothing is there, my lord. In fact, my lord, section does not at all attracted towards me, my lord. In fact, whatever at all, my lord, if the allegation
Let
is
the record come.
admitted, my lord, they must comply the provision of lordship is where, my lord, Anish Kumar and Satendra Kumar Patel, no notice has been served. And my lord, even the arrest memo, my lord, which was served to my relative, my lord, nothing was, my lord, section 48 was not complied. Section 36 and 62,
Okay,
these
we'll-
all were not comply, my lord.
We will see.
Kindly
Let
see
the
the
record come.
rejection order, my lord. Kindly see.
Let the record come.
My lord, I am suffering for 37 days, my lord, behind the bar, my lord. I'm a priest, my lord. I have nothing to do. I'm a religious person, my lord. I'm
Maybe.
running a temple, my lord.
Maybe.
It's for the interest of public, my lord. Where
That's all right.
if at all dispute between the villager and the informant themselves, my lord, where I have nothing rule, my lord. That's what, my lord.
Shall call for the scanned copy of the record along with the case diary, fixing the matter on next 27.
Otherwise, my lord, lordship has already also enlarged on the non-compliance of the order of Satendra Anish Kumar judgment.
That's all
Satendra,
right,
my lord.
but without
Lordship-
perusing the record, how can we appreciate your submission?
My lord, notice has not been served to me, my lord. Admittedly, my lord.
We'll see from the case diary whether it was served or not. Let the record come.
Applies, my lord. Short date, my lord.
27.
Applies, my lord.
May I propose? Well, at this stage, my lord, I am paying for CD only. This is second bail application. Can it be on 28, my lord?
First one was rejected on who is that?
My lord, it was rejected on, my lord.
What is the ground for filing this second application?
My lord, progress of, my lord, substantial investigation, my lord. That is the ground, my lord. Second ground. Earlier, rejection was made, my lord, at that
Let
stage,
the
my lord.
city be produced before the court on
28, my lord.
28.
28.
From where it will come?
Borpeta.
Borpeta, Kolkata CIPS.
Okay, 28.
Deep level. May it be the option. My lord, before I proceed, my lord, I have just prepared a brief, my lord, a list of dates and some vital, my lord, dates essential for your lordships to go through the issue, my lord, and the relevant rulings, my lord. If I may be allowed to place it, my lord.
This is a revision petition.
Yes, my lord, this is a revision which is basically directed against the judgment and order of the learned session court, my lord, Forpeta, dated 30/6/2020, my lord, upholding the conviction of the petitioner. A concurrent finding was given by the learned sessions court, my lord. And he was convicted to undergo a simple imprisonment for a period of 3 months, and an amount of rupees 13 lakhs was given as a compensation, and in default, another 3 months, my lord. Now, but before I go, my lord, the core issue for your lordship to determine is, my lord, your lordship knows that under.
No, today is not the date for determination of the real issue.
Yes, my lord.
Let
ma'am. I'm-
notice go at this stage. Let the record come.
My
Yes, my lord.
Thereafter, we will consider your
Of course, my
prayer.
lord, of course, my lord. My lord, only one aspect, my lord, if I may be correct, if I may be allowed, my lord, the page number 173, if my lord kindly peruse, the warrant NPW has been issued after the, my lord, conclusion of the appeal, my lord. 173, and I was basically, I'm to appear on 31st 08/2026.
Okay, we will stay the operation of the impugned
Yes, my lord.
judgment. and
Kindly, my
order.
lord, may stay, and my lord may allow me to basically go on the previous bill before the learned court below, my lord.
Okay. Heard Mr.
H. Buragohai, my lord.
Learned counsel for the petitioner, and also heard Ms. B. Bhuya, learned additional PP cum senior advocate, assisted by Ms. Wenso for the respondent number 2. In this revision petition under section 42, read with section 438 of the BNSS 2023. The petitioner has challenged the judgment and order dated 38/6/2026 passed by the learned session Judge Barbeta in criminal appeal number 07 of 2026 under section 415 within bracket 3 within bracket small a of BNSS 2023 arising out of NI case number 14 of 2024. Where is the petition and the documents placed on record? No, and also no by which the learned session judge Barbeta has upheld the judgment and order dated 24/12/2025 passed by the learned judicial magistrate first class Barbeta in NI case number 14 of 2024, whereby the learned trial court has convicted the petitioner herein to undergo simple imprisonment for 3 years, 3
3
months, and also to pay a fine of rupees 13 lakhs as compensation for the offense under section 138 NI Act. And further, provided that in default of payment, the petitioner has to undergo simple imprisonment for another period of 3 months. Peruse the petition and the documents placed on record, and also peruse the impugned judgment and order dated 30/6/2026 passed by the learned sessions Judge Barbeta in criminal appeal 7 of 2026, and also the judgment and order dated 24/12/2025 passed by the learned trial court. Issue notice to the respondents returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 2 since Ms. Bhuya entered appearance and received notice. However, it's the requisite copy of the petition be furnished to her during the course of the day. Step upon respondent number 1 be taken by speed post and also by usual process within a week from today. SSL call for the record from the learned courts below and list the matter after 4 weeks and pending further consideration. The operation of the impugned judgment and the sentence so handed down by the learned learned judicial magistrate, learned trial court by judgment and order dated 24/12/2025 and affirmed by the learned sessions as by judgment and order dated 38/6/2026 stand state till returnable date. Till returnable date. Consequently, a non-bailable warrant of arrest issued against the petitioner by the order dated 30/7/2026 by the learned trial court, shall be kept in abeyance. Shall be kept in abeyance. And the petitioner is allowed to remain on previous day.
I'm
Motion
highly
to
obliged.
approve for a fixed date. Fixed date, my lord. 22nd.
22nd, madam.
Item six,
I'm obliged, my lord. Deeply.
22nd
item
September.
number six,
I'm obliged, my lord.
Right. Mr. Lordship, here we have challenged the order dated 10/3/2026 passed by the session judge, my lord. Whereby, my lord, the case of the petitioner, my lord, 3 persons died in a incident, my lord. There are some persons are present and they were examined by the police. They are interrogated, but while the police submitted the charge sheet, my lord, their name is not shown in the charge sheet, my lord. Accordingly, the petitioner filed an application under section 93(9) for further investigation, my lord. And that petition was rejected by the session judge, my lord, stating that, my lord, since the informant has not filed any petition and the petitioner are the family member of the victim, my lord, so they have no locus
Where
to
is the impugn order?
page 38, my lord. Page 38. In paragraph number 2, my lord, the name of the persons who are present in the place of occurrence, my lord. Then, my lord, next page 39, my lord. In the bottom, my lord, the first and foremost aspect of this case is that the present petitioners have no locus standi to file such a petition to, as because the informant of this case, namely Vipul Sharma, is the person who submitted the file, but the said informant is not agreed by the investigation done in this case. But the Vipul Sharma is the executive officer, engineer, my lord. He has filed the FIR, my lord, in the capacity of, my lord, government servant, my lord, not as a family member, my lord, and we are the family member, my lord. Then, then last, my lord, then furthermore, even if the investigation officer failed to name certain witnesses in the case, it will be open for the court to take note during trial, and the court can exercise its power for calling any witnesses who are relevant to the prosecution case, and based on their evidence found, new accused can be implicated in the case, and for that to happen, the court must conduct the trial and thereafter reaching into the conclusion regarding implicating more accused person or to call the witnesses by exercising the power as envisaged under section 311 CRPC. So far as the grievance shown by the present petitioners are concerned, the same does not fit into the provision under section 193(9) BNSS corresponding section 173(8) CRPC. From the perusal of the charge sheet, of which the cognizance was already taken by the learned SDGM, Bileshwar and summons were issued, it appears that as of now the findings of charge sheet are correct and no further investigation is required. So the prayer made by the present petitioners stand rejected.
What wrong with this order?
Because, my lord, the order, our petition was rejected, my lord, only on the ground, my lord, we have no locus, my lord. But there is a judgment of our High Court, my lord, division bench judgment, my lord, whether the victim family or the victim has the locus to file the petition under section 173(8) of the CRPC.
No, who are the petitioners?
Petitioners are the father and brother of the 3 persons died, my lord. 1 and 2 are fathers of 2 victims, and petitioner number 3 is the brother of another victim, my lord. My lord, we have my lord, kindly come to page 33 of the petition, my lord. Paragraph 2. The petitioner number 1 is the father of late so and so. The petitioner number 2 is the father of so and so, and petitioner number 3 is the brother of so and so. Those 3 persons died in the incident, my lord. And the FIR was lost by the executive engineer, my lord, the FIR at page 18.
The question is, it is the prerogative of the IO whom he will cite as witness
was-
or not. He will
Also,
not
my
take the
lord,
dictation from you to
Observed by-
incorporate the
yes.
name of some of the persons.
This also observed by our High Court division bench. my
Maybe.
lord, in the, yes, my lord, I have given the judgment, my lord.
Maybe.
Yes. But my lord, since my lord, our contention is that my lord, the statement was recorded by the IO, but the name of the witness is not shown in the charge sheet, my lord. Accordingly, we have, my lord, filed the petition, my lord.
No, it is the prerogative of the IO whom he will cite
But,
as witness or as accused.
but not only, my lord, accused, my lord, vital witnesses, my lord.
No, that's why.
Yes, my lord. We have stated in paragraph 5, my lord, in paragraph 5 of the petition, my lord.
Anyway, let the record come. We'll see. Heard, Mr.
M. Hussain, my lord.
Learned counsel for the petitioner, Ms. B. Moya, learned additional PP Kama, senior advocate, assisted by Ms. So-and-so, learned counsel for the respondent number. Respondent number 1. In this petition under section 528 of the BNSS 2023, the petitioner has challenged the order dated 15/11/2025 filed by the petitioners. Line 2. Order dated so and so passed by the learned additional session judge Bilasipara in
Session case number 84 of 2025.
session case number 190 session case number 84 of 2025 arising out of Bilasipara PS case number 266 of 2026 under section 304 IPC. It is to be noted here that by the impugn order dated so and so, the learned trial court has dismissed the petition number 1957 of 2025 filed under section 193 within bracket 9 of BNSS 2023 corresponding to section 173(8) CRPC for directing the investigating officer to conduct further investigation of Bilasipara PS case number 226 of 2023. Peruse the petition and the documents placed on record and also peruse the impugn order dated 15/11/2023. Let notice be issued to the respondents returnable inquiries. Step on respondent number 2 be taken by speed post, also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1 since Ms. Puya entered appearance and received notice. However, extra requisite copy of the petition be furnished to her during the course of the day. This is a call for the scanned copy of the record from the learned trial court along with the case ID. Place the matter after 4 weeks.
My lord. Obvious.
You keep this judgment with you. You
Fine.
can produce it at the time of hearing.
Obvious.
He has made the informant as a party respondent. Lordship is free notice.
Yes.
Item 7.
Even this case notice was not issued, my lord.
Pardon?
Notice was not issued, my lord. Earlier it was court.
This is
paid,
petition for
the-
passing.
But our record says on 23/7 issue notice, call for scan copy of TCR. I may be
Yes.
wrong, but that's
Scan
written here.
copy was called, my lord, but unfortunately
Notice has not
notice
been
was not
issued. Heard means that
HLS.
learned counsel for the petitioner and also heard Ms. B. Sharma, learned additional PP for the state respondent. The learned counsel for the petitioner has pointed it out that though by order dated 13/7/2026, record has been called for, yet notice is yet to be issued to the respondents. Accordingly, it is provided that notice be issued to the respondent returnable in 4 weeks. Step be taken upon respondent number 2 by speed post and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1 since Ms. Bhuya entered appearance and received notice. However, extra requisite copy of the petition be furnished to her during the course of the day. Office note dated 17/8/2026 indicates that the case record along with the case diary of PRC case number 3498 of 2025 has not yet been received. Justice shall issue urgent reminder to the learned court below for transmitting the scanned copy of the record. List the matter on
Interim may be continued, my lord.
Date you.
23rd.
interim order passed earlier shall continue.
23rd. 23rd of September.
Most of it.
Item 9.
May I please, your lordship? Lordship, the impugned order is at page number 37, your lordship.
Mm.
NBWA was issued against me, your lordship. And prior to this, your lordship, on 6th occasion, I remained absent, your lordship. Page number 37 is the impugned order, your lordship.
Why you remain absent?
Lordship, lordship may also see page number 30, your lordship. The case got transferred from one court to another, your lordship. Thereafter, I was not represented by my NDS counsel as far as NBW was issued, your lordship. And same was not within my knowledge, your lordship, admittedly, your lordship.
No. Earlier you entered appearance before the court.
Lordship, I was represented, your lordship. I was represented, your lordship. Next date is on 27/8/26, your lordship. I am ready to appear and go on fresh bail, your lordship. If lordship allows. The first step.
Heard, Mr. Your name?
Assessment, your lordship.
Learned counsel for the petitioner, Ms. B. Bhuya, learned additional PP for the state respondent. In this petition under section 528 of the BNSS 2023, the petitioner has challenged the order dated 14/10/2025, 9/12/2025, 3/1/2026, 11/3/2026, and 5/5/2026, 22nd of June 2026. Passed by the learned additional chief judicial magistrate
He
Moregaon.
is absent all along, my lord. I don't find any of the orders
In
wherein
PRC case number 2307 of 2021. It is to be noted here that by review order dated so the learned trial court has issued non-bailable warrant of arrest against the present petitioner. You are on representation.
I was representation on previous occasion, your lordship.
on which date?
On page number 30, from thereafter NBW was issued, your lordship. Page number 30, your lordship. 16/8/25 case was transferred from CGM to your lordship, additional CGM. Thereafter on 22/8/2025, I remained absent, your lordship. Neither I was represented, your lordship.
You are absent all along. You have not
Lordship.
annexed anything in order to. Yes, তার আগৰ- Not even a single occasion, my lord.
6 occasion, Your Lordship. NBW was issued, Your Lordship. Same was not executed as I am a resident of Bongaigaon, Your Lordship. For my business purpose, I remain outside many a time, Your Lordship. So it was not executed and not within my knowledge, Your Lordship. I came to know from the co-accused, Your Lordship, who is appearing.
His conduct seems to be not proper, my lord.
No, earlier you have engaged one counsel.
Lordship, that is page number 27, Your Lordship.
Hmm.
On 8/11/2021, Your Lordship,
Hmm.
the case was taken up by learned CGM, Your Lordship. Page number 27, Your Lordship.
Cognizance is taken under so and so.
Your Lordship, on
That's it.
8/11/2021, cognizance was taken, Your Lordship. Thereafter, due to restrictions of court functioning, Lordship, and I appeared for the I was represented. I was appearing through my counsel on, Your Lordship. On page number 28A, Your Lordship, 12/7/2024, Your Lordship.
Learned counsel for the petitioner submits that earlier this case was pending before the Court of Learned Judicial Magistrate, wherein he was represented by his engaged counsel, but subsequently by order dated 16/8. 16/8/2025, the case has been transferred to the Court of Learned Additional Chief Judicial Magistrate, Moregaon. And on account of the case being transferred to the Court of Learned Additional Chief Judicial Magistrate, Moregaon, the counsel for the petitioner and the accused also, no, and the petitioner also could not appear before the learned trial court. No, before the Court of Learned Additional Chief Judicial Magistrate, for which non-bailable warrant of arrest was issued against him. He also submits that the accused is ready to face trial and will appear before the learned trial court on each and every date, and therefore he is contented to allow this petition. Yes,
My lord, petitioner may appear on
I will
a
appear,
short
Your
date.
Lordship.
the learned
27.
petitional plea for the state respondent submits that the petitioner may be directed to appear before the learned trial court fixing a short date. Accordingly, taking note of the submission of learned counsel for both the parties, this court is inclined to dispose of this petition by directing the petitioner to appear before the Court of Learned Additional Chief Judicial Magistrate, Moregaon, on or before
Lordship, 27/8 is the next date, Your Lordship. Very recent.
27/8. 27/8. And to apply for regular bail or to allow him to remain on previous bail, and in the event of filing such an application, the learned trial court shall consider the same in accordance with law. Till then, the non-bailable warrant of arrest issued against the petitioner shall be kept in abeyance in terms of this petition's disposal. At this motion,
Much appreciated.
That is all. Ballot, it's an application ballot under section 528 of BNSS ballot. We have challenged this order, my lord. Your lordship will find at page 40.
Your Zimma petition was rejected.
Rejected, my lord.
Where is the impugn order?
Your lordship will find at Annex 7, my lord.
Page 40.
Page 40. My lord. Rejected on the ground that, my lord, color is not matching. My lord. So this is the ground, man. In fact, that is his own contradiction, man, with regard to the color of this is cattle, man. Your lordship will see that, my lord, the inventory, my lord, at page 34, man. That is by himself, man. Page 34. A photograph of one blue color so and so vehicle bearing registered number so and so, carrying 8 numbers of cattle, out of which 4 numbers white color male cattle, 3 numbers muga color male cattle, and 1 number Kozala color male cattle. This is the description, man, of the seized cattle, man. Now your lordship will kindly come to, man, the impugn, man, the order. My lord, what is the reason, my lord, assigned by this, my lord, impugn order, my lord? My lord, third paragraph, if your lordship goes through this, my lord, third paragraph, it is seen that as per the health certificate of the seized cattle provided by the veterinary officer dated so and so, 05 of the cows were stated to be white, one is found, one is brown and white, and another is blackish brown. That is, my lord, contrary to the, my lord, this inventory, my lord. That is, as per this order, my lord, this is from the photographs. That is his own assumption, my lord. In fact,
Whose assumption?
own assumption, my lord. From the photographs, my lord, what was, my lord,
No,
prepared?
you see, it is seen that as per the health certificate of the seized cattle produced by the veterinary officer.
Yes. 05 of the cows were stated to be white.
Mm.
One is found, one is brown and white, and another, that is, your lordship will kindly come to next paragraph. It is seen that the description given by the petitioner does not match with the seized cattle, as the photographs submitted by the IO at the time of seizure matches with the description given on report dated so and so. So that is contrary to the, my lord, seizure, my lord, what is the seizure description in the seizure, man? That is page 34. As per the inventory, my lord, this is not as per the certificate, man.
Not as per?
Not as per the
Sorry
certificate.
to interfere. That confusion may be because page 34, white color male cattle,
Mm.
3 numbers muga color.
Mm.
So maybe because they are report says it's in English,
Mm.
muga color, male cattle, and 1 Kozola color. So they might be because these letters are in English, my lord. The order which has been reflected. Let the record come, your lordship.
In fact, this is color is not cannot be.
Because one in vernacular, other one is in English.
Yes, Muga color is, my lord, if we accept that, my lord, the, my lord, health certificate, my lord, there is no difference, my lord, with regard to the color of the seized cattle, my lord. But, my lord, that was the basis, my lord, rejecting my lord, application, my lord.
Muga and Kozola.
And then nothing, my lord, seizure list is not disputed, my lord. And other all these, my lord, this is not disputed, my lord. Only, my lord, the description with regard to the color.
Let us do one thing.
My lord.
Let the SDGM
My lord.
release the seized cattle in the custody of the petitioner as per who were seized as per the seizure list.
No, chief.
Let the report come first, my
What
lord. Then the
report?
lordship will.
What report?
From the IO, your lordship.
My lord, seizure list is not disputed, my lord, in the impugn order, my lord. Seizure, as per the seizure list,
At once releasing the cattle in the hand of the accused petitioner, maybe. My
No,
lord.
there is no dispute about the ownership of the cattle.
Yes, but the
Is
colors
there?
differ. I also making the submission because of it's in vernacular and in English. Let a report come, then thereafter your lordship may
and
propose
if, my
appropriate
lord,
order.
Assamese
as
is,
per
my
the-
lord, compared to the English, my lord, the description of the color, there is
Now,
no difference.
where the seized cattle are being held?
And that is in the Gosala, my lord.
Gosala.
Gosala.
And for that, you have to pay the cost also.
Yes, yes, my lord. In
Lordship.
fact, that is purchased for, my lord, agricultural purpose. It's being, my lord,
Report to lordship. They have more experience than me. Lordship,
Pardon?
this matters. My learned colleagues have more experience in this matters than me. Lordship, may report may be called for.
Why report
Ranjan.
is necessary? There is contradiction in
Muga
respect
and
of the
Kozola,
color
huh?
of the cattle.
Yes.
The
Mugaru
in
Kozola
between the certificate issued by the veterinary doctor and also by the also
Photographs, my
with
lord.
that of the seizurement
At the time of seizure, the photographs.
photographs.
In fact, this is from the photographs.
That maybe CD may be called for CD. I will have to verify from those records, my lord.
Can you verify the color from the CD?
নহয় নহয় কথাটো কি হৈছে জানা অসমীয়াত লিখা আছে মুগা
The
কজলৰ
color doesn't extinguish my
এইটো
ownership.
ৰিপৰ্টটোত চোৱা ৰিপৰ্টটোত লিখা
Otherwise,
আছে
my lord, regarding my
report,
lord,
sir.
release of
The
cattle,
English
there
are
is a specific bar in the under the provision of the act, my lord, for releasing the cattle, my lord.
Where?
Section, my lord, Assam Cattle Preservation Act 11(5) of the, my lord.
11.5, what is there? Is it bar?
Yes.
অসমীয়া ইংলিছ মোৰ মতে সেইটোৱে লিখা আছে নাই নাই হোৱাইট অন ব্ৰাউন
Section 13(11)(5) of the, my lord, Assam Cattle Preservation Act, my lord. On receipt of the report, judicial magistrate first class may, on his being satisfied that there is enough material to presume that a prima facie offence under this act has been committed or intended to be committed, release the seized materials including the vehicle conveyance except my lord cattle on furnishing of the bank run. So there is specific bar. my lord. There are also, my lord, some Supreme Court decision also there in this regard, my lord. So that has also to be, my lord.
No, the word except is omitted
My lord,
by the Act of 2022.
omitted the word except
my lord, I will my lord, regarding that also there is.
The bar is not there now.
Yes, there is
I will,
no now.
I will place before your lordship the exact notification, my lord. Because there is some that omitted the word except, my lord, regarding that portion, my lord, there is some, my lord, confusion is there, and later on, my lord, recently, my lord, in a judgment, that confusion was, my lord, clarified by one of my lord, colleague. Your lordship may fix it day after tomorrow or tomorrow, my lord, I will clarify your lordship. Regarding that except word also, my lord, in the original notification, there is some.
No, Mr. Borthakur, you see, if there is no dispute regarding the ownership, why should I keep this matter pending?
Your lordship may pass it.
or it may be released not in favor of the accused petitioner but to Gosala, my lord.
It
Is there
is already, my lord, under the Gosala, my lord.
provision is there?
Okay, you produce the notification if there is any clarification made by the government subsequently. We will take it up at 2 o'clock.
No, sir.
Okay, no, 2 o'clock, 2 o'clock not possible. After some time?
Well, can it be tomorrow, my lord?
At
Tomorrow.
2, my lord, your lordship may have it, my lord.
No, pardon?
At 2, my lord, if your
No,
lordship.
tomorrow we have some other fixed matter.
Lordship. Then tomorrow, my lord.
Tomorrow is also the same position.
On Friday then, my lord.
Then Friday,
No.
my lord.
No, not Friday. Today after some time.
Yes, my lord.
Yes, Mr. My lord, by way of this criminal petition, I'm praying for quashing of a complaint case, number 1/2022, pending before the judicial magistrate first class at Jonai. And also for quashing of the cognizance order dated 9/3/2022.
What are the grounds?
My lord, basically, this is a civil matter which has been converted into a criminal proceeding.
You have issued the SEC?
My lord,
You have issued the SEC?
my lord, again, there are two, against the issuance of check, he has filed a separate complaint case. Two complaint cases are filed. My lord, the first complaint case, which is impugned, my lord, is page annexure 10, page 35. It was filed on 18/1/2022, which is impugned. This is the, my lord, translated copy. The vernacular copy starts from page 41. And my lord, against the same allegations against the same incident, that the sum of rupees 1,53,000, the second complaint case which was filed, my lord, the complaint is at page 54, annexure 15. On 28/2, that is after lapse of 1 month. This is under NI. Two complaints against the same petitioners. And the allegation is same one. There the allegation of cheating, 420, 406, as well as 193 was also included, man. 193 is giving false evidence during judicial proceeding, and upon which also the cognizance has been taken, man.
No, maybe. Is there any bar in proceeding against you under both the provision?
No, my lord, to be fair, there is no bar. But then, my lord, the quashable ground which I am presenting before your lordship is that the dispute in nature is completely civil, commercial in nature. Against commercial transaction, my lord, if a criminal color has been given, that amounts to abuse of process of it. Even, my lord, it peruses the cognizance order, which is at page 13, page 50. My lord, complete non-application of mine. There is category of judgments of the Honorable Supreme Court, which says that criminal proceeding cannot be a substitute to civil proceeding. 9322, my lord, simply says that complainant has submitted written complaint against the accused person, Amit Podar and Virendra Podar, peruse the case record. After examining the complainants under section 200 CRPC, prima facie I have found sufficient materials as alleged for proceeding against the accused persons, Sri Amit Podar and Virendra Podar, under section 420, 406, 193. And one of the grounds, my lord, is for constituting an offense under section 420. The most important ingredient is that the intention to deceive must be from the very beginning. And section, my lord, the learned trial court has taken cognizance under section 193. 193 is regarding giving false evidence during a judicial proceeding, which shows that there is a complete non-application of mine. My lord, if my lord peruses the complaint, page 37, my lord. The intention to deceive has to be gathered from the complaint. My lord, may I read para 4, page 37. That the accused person within a very short time with their clear talks were successful to win the faith and trust of the complainant and the witness number 1. And the complainant on 25/11/2021 paid an amount of rupees 9,42,800 in the account of the accused number 1 for procuring the articles mentioned in the list. Even after a week from the date of depositing the aforesaid amount in the bank account of the accused number 1, as the articles mentioned in the list were not sent, the complainant had to call the accused person through mobile phone many times. After showing various excuses, the accused person finally on 2/12/2021 sent the articles of total rupees 7,89,800 mentioned in the list in a goods carrier truck bearing registration number such and such. The accused person sent less goods rupees 1,53,000 than order placed by the complainant and the money paid by the complainant. Immediately when the complainant asked the accused person the reason why they sent less goods, the accused person started showing various pretexts. When the complainant refused to accept the less goods sent by the accused person agreed to return back the balance amount of rupees 1,53,000. When the complainant felt that the accused person are trying to deceive the complainant, he sent the witness number 2 and 3 of Junai, who are staying in Gauhati, to the shop of the accused persons located at Ganeshguri. The accused number 2 handed over a check in the name of complainant against the balance amount of rupees 1,53,000 to the aforesaid person sent by the complainant. Now, para 6, my lord, says with regard to the check return bounced, Your Honor, due to want of fund. Now, Your Honor, there are certain applications. Now, para 8 says, having no alternative, the complainant on 18/12/21 sent a written notice through his engaged advocate to the accused person, and thereafter on 30/12/21, the accused person sent a reply to the said notice to the engaged advocate. My lord, now if my lord comes to para 9, para 9 sub.
Okay, all right. Having perused this complaint, can it be said that 420, 406, these are not made out against you?
My lord, the settled position of law is that under 420, for making any offense under 420, the intention to deceive must be from the very beginning. And if my lord, here in this case, 9 lakh amount was transferred, I transferred an amount goods worth of rupees 8,98,000. So dispute with regard to non-payment of certain goods or refund of money, Your Honor, it's a completely civil matter. In this regard, my lord, there is a judgment passed by my lord itself.
No, maybe.
So, my lord,
let the record come at this instance.
my lord, the matter is fixed on 21/8.
Maybe you file an application there.
My lord, as and when we came to know, my lord, we approached this one.
Pardon?
When my lord, we filed this matter.
Lordship may kindly see, date order date 21/7/2026.
Yes.
This matter has been pending since 2022. He is not entering appearance, your lordship. As a result of which, this honorable court directly prepare summon in duplicate and transmit the same forthwith to jurisdictional court, allow with a request to cause service through a process server. And the next date is fixed on 21/8. Lordship, scan copy of TCR may call for, but no stay be given in this
My lord,
matter.
my humble submission.
Repeatedly,
My humble submission, the
order not appearing
submission is
in the
incomplete.
court.
My lord, 21/7/26, my lord, the order starts from page 52, not the last person. It says, bailable warrant of arrest issued against the accused person have not been received along with the report. It is seen that the instant case filed in the year 2020 until that no report has been received. No copy was served upon me. No report has been served upon
That
me.
is your defense.
No. That is what the record says, my lord. Just reading the last portion will not suffice. Now, 52.
I have gone through it.
Yes.
My lord, he is repeatedly flouting honorable court's order. That is the
No, my lord.
tactics,
Unless-
my lord, they
no,
don't
my lord, no,
receive
my lord.
summons sent by the honorable
My
court.
lord, my lord, may I read the entire order?
No, not necessary. Let notice go.
My lord, I will just like to place one judgment of the Honorable Supreme Court, which
Not
clearly
not
says,
necessary. Not necessary.
my lord, at this moment, my
We
lord,
we are
on
not
20
saying the proceeding now.
my lord, on 21/8/26, my lord, the order taking cognizance, my lord, it's completely non-speaking, my lord.
We'll see. Let the record come.
My lord,
If it is a non-speaking, definitely we will interfere with the same.
my lord, if my lord permits me to just place one judgment.
No,
My lord, at
we
least
are
the
not
order.
finally hearing and disposing of the matter. Heard, Mr. Your name?
A.K. Rai, my lord.
Learned counsel for the petitioner. And also heard Ms. B. Bhuya, learned additional fee. Senior advocate assisted by Ms. So for the respondent, state respondent number 1. In this petition under section 528 of the BNSS 2023, the petitioner has applied for quashing the complaint case number 1 of 2022 filed by the respondent number 2 against the petitioner, which is standing before the Court of Learned Judicial Magistrate First Class at Zone. And also the petitioner has challenged the order dated 9/3/2022 passed by the Learned Judicial Magistrate First Class Zone, whereby it has taken cognizance against the petitioner under 6420, 406, 193, 120B, 506 IPC. And also challenge the no, not necessary. Peruse the petition and the documents placed on record, and also peruse the complaint case number 1 of 2022 and the order dated impugned order dated 9/3/2022. Issue notice to the respondent returnable in 4 weeks. Step be taken by state post and also by usual process within a week from today upon respondent number 2. However, no formal notice is required to be issued to the respondent number 1 since Ms. Bhuya entered appearance and received notice. However, extra requisite copy of the petition will be furnished to him during the course of the day. Registrar shall call for the scanned copy of the record from the learned trial court. Place the matter after 4 weeks. Interim period of the petitioner will be considered on receipt of record from the learned trial court on next date.
Order, second number 31.
Yeah. Lord, they have not filed affidavit. They are not inclined to file affidavit, my lord.
Pardon?
The state respondents are not inclined to file
Lordship,
affidavit.
I'm leaving it to your lordship because I didn't get any up-to-date instructions, your lordship. It's the instructions that I have been receiving several times is that which I have placed already, your lordship, before your lordship.
So you are not interested to file affidavit?
No.
Then we will Finally, hear and dispose of this.
Yes, your lordship, your lordship.
Not today.
Your lordship may fix it.
Heard Mr. Professor Learned Counsel for the petitioner and also heard Ms. Terampi Learned Standing Counsel for the Secondary Education Department. Ms. Terampi submits that the department will not file any affidavit in this matter. Accordingly, taking note of the submission of Learned Counsel for both the parties, it is provided that recess lays the matter on 10th of September for final consideration.
Obliged.
Okay, good. Wait, cover.
Then 32.
As per my lord, office note, as per office note, it is 17 my lord, service report is awarded now.
Heard Mr. Islam, Learned Counsel for the petitioner. Office note dated 14/8/2026 indicates that notice issued to the respondent, sole respondent. No, notice was issued to the sole respondent by speed post as well as through the district message South Salmara, Mankasar. But the office note is silent in respect of service of notice upon the respondent. Accordingly, it is provided that this is a put up one up-to-date office note in respect of after taking the service of the notice from the website of the postal department. On next date, this is release the matter on next week, 31st August.
All right. 33.
May I please, your lordship? Lordship, I am appearing legal aid counsel in the matter. This has been filed for condonation of delay of 347 days in filing the connected appeal, lordship. The grounds has been mentioned in paragraph number 4, 5 and 6, lordship.
What is the ground?
Lordship, the delay has occurred due to the processing of the documents, lordship. Although the accused has filed the application.
When you were engaged here?
Lordship.
When you have been engaged here?
Lordship, I have been engaged only recently, lordship, in the month of 13/7/2026, lordship. Within 1 month, I have filed. Paragraph number 6, page number 6, lordship. The delay, whatever is caused in the process, lordship. Because earlier, some other legal aid counsel was given the duty, lordship. Thereafter, she handed over the file. Thereafter, I was engaged.
Okay. Okay. Heard Mr. Soduri, Learned Counsel for the applicant, Mr. Borthakur for the respondent. This interlocutory application is preferred by the applicant, Sri Bijoy Kolita, for condonation of delay of 347 days in preparing criminal appeal under section 415 within bracket 2 of BNSS 2023. Against the judgment and order dated 2/7/2025 passed by the Learned Additional Sessions as Kamrup Amingao in session case number 70 of 2023. Convicting the applicant under section 326, 341 IPC and sentencing to suffer rigorous imprisonment for 5 years and also to pay a fine of rupees 50,000 only with a default stipulation under section T26 of the IPC and also sentenced him to suffer rigorous imprisonment for 1 year, 1 month for the offense under section 341 IPC and further directed that both the sentence shall run concurrently. So Chaudhary, learned legal aid counsel for the applicant submits that he has been engaged in this matter on 13/7/2026 and earlier another counsel was engaged by the office of the High Court Legal Service Committee.
Yes,
Court
Lordship.
Legal Service
Paragraph number
Committee.
5, Lordship, page number 5.
And the said counsel could not proceed with the matter and handed over the file, and subsequently he has been given the tax. And within a period of 1 month from the date of receipt of the file,
Lordship.
he has prepared the appeal and the application also. And he further submits that the delay of 374 days, 347 days occurred during while the file was processed by the Legal Services Committee and there was no intentional delay, and the same is circumstantial and there is merit in the appeal, and therefore he has there is arguable point in the appeal, and therefore he has contended to condone the delay and to hear the appeal and to decide the same on merit. Mr. Portago, any objection?
No, man.
Mr. Portago, learned additional PP submits that he has no objection in the event of condonation of 347 days delay in filing the criminal appeal. Having heard the submission of learned counsel for both the parties, this court is carefully gone to the application and the documents placed on record, and also gone to the record, and it appears that the delay has sufficiently been explained in paragraph number 3, paragraph number 4, 5, and 6. And accordingly, this interlocutory application stands allowed. Delay of 347 days in preparing the connected appeal stands condoned. In view of the order passing this interlocutory application, the registrar shall register the appeal and list the same before the court as soon as practicable.
Oblige, Your Lordship.
May I please, Your Lordship? Lordship, as per the office note dated 17/8/26, the service upon respondent who is still awaited.
Heard, Mr.
ZH Bora.
Learned counsel for the petitioner and Mr. Portago, learned additional PP for the state respondent. Office note dated 17/8/2026 indicates that notice was issued to the newly implemented respondent number 2 through the officer in charge, Ding Police Station on 10/8/2026. But the service report is still awaited. Accordingly, it is provided that, is it FOXO matter?
No, it's a murder matter which comes under, no,
Pardon?
it's a murder case
Okay.
along with arms act.
Accordingly, it is provided that Mr. Portago shall obtain a service report from the officer in charge of jurisdictional PS, then apprise this court on next date. List the matter on 3rd of September.
Lordship, possible.
May it please, Your Lordship. In this particular review petition, Lordship, some pagination mistake has been occurred, Lordship. Lordship, in earlier occasion, Lordship, Honorable Court allowed to make correction, Lordship, but in order, Lordship, it was not reflected. That is why they refused to allow permit us to correct, Lordship. In review petition, Lordship, some pagination.
This IA is for?
IA for condemnation, Lordship.
Here, notice was issued?
No, Lord. In main petition, Lordship, review petition, Lordship, some pagination mistake is occurred. Lord.
No, this IA, why this IA is filed?
I have for condemnation for 73 days condemnation.
No, review petition is yet to be registered.
Serial number is created, Lord. Serial number A8014. Lordship.
Order is any bottom. Third, Mr.
Yes, Sharma, Lordship.
Learned counsel for the applicant. This interlocutory application is preferred by the applicant under Section 5 of the Limitation Act for condonation of delay of 74 days in filing review petition. For reviewing the order dated 17/3/2026 passed by this court in CRPI number 521 of 2025. Let notice be issued to the respondent, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. The learned counsel for the applicant submits that in the main review petition, while making pagination in the some mistake crept in, and the same is required to be corrected. And as such, he press for according him permission to make necessary correction in respect of the pagination in the main review petition. Pair allowed. Pair allowed. List the matter after 4 weeks. You take step in the IA.
Deeply.
Supplementary list, item number 39.
This was essentially a tax dispute where for my lord non-issuance of a Form C, they say that the allegation is that concessional tax could not be availed. Now a criminal complaint was filed against us, my lord, for non-issuance of Form C, and cognizance was taken. There was a stay, my lord, given on the proceedings of the complaint case on 16/3/2026. The office note, however, today says that the notice is, my lord, not served.
Whether we have taken a step.
My lord, we have taken steps on 19th, I think, thereafter.
No, the notice is returned answer with a report that no such person in the address.
My lord.
No, in the address, RTS.
Probably the address is wrong. But then this was the address given in a complaint, so we had to use this address only.
You obtain inspection.
My lord. Otherwise, we had taken steps on
Heard Mr.
16th.
Pathak, learned counsel for the petitioner. Office note dated 18/8/2026 indicates that notice issued to the respondent returned with a report. No such person in the address, RTS. Accordingly, it is provided that Mr. Pathak shall obtain necessary inspection in respect of the correct address of the respondent and shall take fresh step upon the said respondent within a period of 1 week from today.
1 week, my lord.
Rest is a later matter after 4 weeks.
My lord, the interim
Order shall continue.
Deeply out.
Hearing item number 23.
DPS case diary was called for. As the case diary has come. Case diary received.
Is there any material?
Material is there, my lord. Material is there from our
Material
possession.
is there.
Yes, from our possession, commercial quantity of contraband was recovered, my lord. Now, our only ground is, my lord, violation of 47 and 48. Your lordship will kindly see page 17, my lord.
Page 17 is the my lord, type copy of the grounds of arrest, which the vernacular is in page 18. If your lordship will see, these fall in the category of reasons of arrest, my lord. The accusation against me, my lord, that is missing, my lord.
That is
Missing from this grounds of arrest, my lord. As required by Prabhu Purkash's judgment, my lord. Distinction between grounds of arrest and reasons of arrest, my lord. Same with the 48 notice also, page 19.
which is the 48 notice.
48 my lord, page 19. That's a type copy of the grounds, and original is at page 20, my lord.
So notice was given to the relative or family member.
Yes, my lord. Notice was given to me as well as to my family members. Now, my lord, if your lordship sees the notice, the grounds which are given, my lord, Prabhu Purkashta makes a distinction between, my lord, grounds of arrest and reasons of arrest. So this can at best be called reasons of arrest, my lord, because grounds of arrest would imply at least gist of the accusation should be there in
No, the question is whether any prejudice is caused to you.
My lord, if
you have filed a bail application before the trial court.
No, this
after
is the,
your
no,
arrest.
this is the first application before this honorable court.
No, it may be the first application before this court,
No,
but before the
no,
trial court, you have not
no,
applied
not
for
filed any
bail.
application. My lord, if you had filed an application on the day of remand itself, perhaps then it could be said that we were aware of the grounds of arrest, so we could file an application, so prejudice was not caused, my lord. Because after Sonam Raghuvanshi, my lord, lordship knows now the prejudice test has again been brought in, my lord. So, my lord, here, my lord, the fact that the family, because family members would be the ones who would be filing the bail application, my lord, on his behalf, my lord. So the family members, though they got a notice, the notice does not disclose, my lord, the grounds why he has been arrested, my lord. So that deprived them the opportunity.
No, some grounds are there. Would it not amount to substantial compliance?
Not in terms of, my lord, Prabhu Purkashta, my lord. No. Para, my lord, 47 and from 47, my lord.
No, that is there.
Yes, my lord.
But in subsequent decision, the prejudice test has been
Yes.
laid down.
Yes, my lord.
Whether you have been caused any prejudice.
Well, one form of prejudice in my respectful submission would be, my lord, the purpose of giving the 48 notice to the family members is because the family members would be
No,
able
you
to
see, these
oppose the remand.
decisions were subsequently clarified by the Supreme Court in the case of Sri Darshan versus state of Karnataka.
Yes.
And also in Sonam Rajvanshi.
So, Raghuvanshi is the latest one, my lord. Yes.
So, if we apply the said test, can it be said that prejudice is caused to you?
Yes, my lord. My submission, my lord, respectful submission is that the purpose of the 48 notice is so as to enable because the accused gets taken into custody. The purpose of the 48 notice is to enable the family members to know why he has been arrested so that he can oppose the remand or he can file a bail application. Now, if the 48 notice does not contain the gist of the accusation, what is the actual allegation against the person, my lord? The person, the family member, is not in a position to oppose either the remand or to file a bail application, my lord. So, in my respectful submission, that would be the demonstrable prejudice, my lord.
No, you see the ground number 3.
Yes, my lord. Yes.
Is it not a ground? Page number 20.
Yes, my lord. I have seen.
Page number 20.
But now this does not make a distinction whether it's a small quantity, intermediate quantity, commercial quantity, whether it is whether the 37 bar would be there or not. What is the nature of the contraband? Because Prabhu Purkashta first judgment, my lord, which primarily says that, and that part has not been taken away in any of the judgments. Only the prejudice element has been brought in. That the gist of the accusation. What is the actual accusation against me? In here, my lord, I was found in possession of some cough syrup bottles and, my lord, tablets, my lord. That should have been reflected. What is the actual offense against me, my lord? Because in other notices, your lordship must have seen, my lord, they give detailed grounds, my lord. Here, my lord, this is missing. That, my lord, my limited submission can be only on this point, my lord.
Yes, Bortakar?
Otherwise, my lord, yes, here I am relying on my lord, here in this case, my lord, all those grounds অপৰাধৰ ভয়াবহতা আৰু NDPS আইনৰ অধীনত কঠোৰ শাস্তিৰ বিধানলৈ চাই আপুনি আইনী প্ৰক্ৰিয়াৰ পৰা so all these my lord grounds of arrest were my lord in mentioned my lord and regarding prejudice test my lord Sunam Raghuvanshi thereafter my lord our division bench high court judgment recently my lord pronounced my lord on 12/8/26 they are also my lord question of prejudice my lord division bench has also held and thereafter my lord recently one Baldev Singh judgment in that judgment where my lord it has been specifically stated that in case of my lord if my lord in the form of drug abuse my lord if sovereignty my lord there is in the form of drug abuse my lord if sovereignty is affected then my lord fundamental right also my lord then question of fundamental right will also not come my lord.
Which matter?
In one of the judgment Baldev Singh my lord.
That is a case, Baldev Singh, where the issue was the prolonged in the plea was taken that because of prolonged incarceration,
because considering
Article 21 gets violated. So Honorable Supreme Court said that drug menace is a war against the country. Sovereignty of the country is affected. So in that case, 37 would prevail and 21 cannot be resorted to.
Yes.
It was for on the ground of prolonged incarceration.
And
No,
here,
whether that proposition can be applied in the present case.
here, my lord, Sunam Raghuvanshi, my lord, thereafter our division, I will place all these both the judgments and my lord, their judgment also I will place before your lordship. And here, considering the gravity of the offence, these are NDPS commercial quantity. So, my lord, NDPS Act, while commercial quantity, my lord, recovered from the possession of
No, Mr. Bortakar, you say what prevents you from mentioning the grounds of arrest properly?
Yes, my lord, that is, it is not that, my lord, the grounds of arrest totally not, my lord, served to the accused person. Grounds of notice, my lord, grounds of arrest, those 47 and 40, but that, according to him, that is not adequate, my lord. So, question of adequacy or inadequacy, my lord, regarding that aspect, my lord, because he has appeared before this honorable court, after getting information, he has filed bail petition, and in this type of heinous offences, my lord, his approach first should be approached before the trial court. There, in that case also, there are judgments of the Supreme Court.
No, whether he had applied for bail before the trial court?
No, he has not applied before the trial court. He has directly approached.
Okay. What is the case that you will say?
Yes. So considering all these aspects, my lord, NDPS commercial quantity recovered from his operation and 3 recent judgments of the Honorable Supreme Court also support our case. Considering that, my lord, okay, this is not
Resume after 5 minutes.
May I please to lordship.
Yes, citizen.
My lord,
well, in this case, charge sheet submitted.
Charge sheet submitted.
My lord,
Okay, let the scan copy of the record come.
CS number 68/26.
Heard, Mister, your name?
Jad Hussain.
Learned counsel for the petitioner. And also heard Mr. Bortakar, learned additional PP for the state respondent. This application under section 483 of the BNSS 2023 is prepared by accused who has been languishing in jail in connection with Patarkandi case number 26 of 2026 under section 22C of NDPS Act. Mr. Bortakar learned additional PP submits that this matter the IO has completed investigation and submitted charge sheet being charge sheet number
68/26 dated 19/6/26.
Accordingly, it is provided that her SSL call for the scan copy of the record along with the case diary from the learned trial court fixing the matter on 7th of September.
Highly obliged, my lord.
If can you pass over this matter for the day, this matter may come up next week any day.
Why?
The leading counsel M. Ahmed is facing some personal.
Who is the counsel?
M. Ahmed.
M. Ahmed. Your name?
A. High.
You can argue the matter.
I'm not prepared.
Mr. A. Hai, learned counsel, appearing on behalf of Mr. M. Ahmed, learned conducting counsel for the applicant. Press for adjournment of the matter for the day. Pair allowed. Recessal list the matter. Okay, not necessary. For the day. Till next CDB retake.
Well, in this case, charge sheet file, my lord.
Charge sheet file.
My,
When?
my lord, on 29/7/26.
29.
7, my lord.
Look at the trial court records may be called for.
Charge sheet number, my lord, 50.
Heard, Mr.
KJ Saikya.
KJ Suikia, learned counsel for the accused, and Mr. B. Sharma, learned additional PP for the state respondent. So Sharma apprised this court that after completion of investigation, the IO has submitted charge sheet being charge sheet number
58, my lord.
58 of 2026 dated.
Dated, my lord, 29/7.
Accordingly, it is provided that recessal call for the scanned copy of the record fixing the matter on 2nd of September.
Deeply.
26.
It's a regular bill application. Case under, my lord, 20B to C of the NDPS, my lord. 37.94 kg of ganja was recovered from the house of the accused petitioner, my lord. Here, my lord, our submission is, my lord, that the person who was taken into custody was not produced before the magistrate within 24 hours of being taken into custody. Your lordship will kindly come to the FIR, my lord, which your lordship will find at page 12. Page 13 would be the relevant part, my lord. That part may I read, my lord.
When he was arrested?
My lord, he was taken into custody at 1 p.m. of 7/7/2026. They have shown the formal arrest at a subsequent point of time.
1 p.m.
1 p.m. of 7/7/2026, my lord. But police has shown the formal arrest, my lord, at 10 p.m. of 7/7/2026.
Yes.
And my lord, he was produced on 8/7/2026 after 3:30 p.m. my lord, as per our instruction, but the order does not disclose the time. So my lord, perhaps the learned friend can address this honorable court on the time was that would be there in the CD at which he was produced before the court, my lord.
At about?
As per our instruction, at about 3:30 p.m. my lord.
So if he is formally arrested on 7/7/2026 at about 10 p.m. and produced on 8th of July at about 3:30 p.m., then it is within the period of 24 hours.
Honorable Supreme Court has said, my lord, and court benches have also said, my lord, that it is the time in which the person is taken into custody, where he loses his physical personal freedom, my lord. That is the period from which this 24-hour period is to be calculated, my lord. Because from that
In
point,
which case it is
my lord, multiple judgments, my lord, from Niranjan Singh and Dinesh Kumar of the Honorable Supreme Court, and I'm giving all the judgments, my lord. Niranjan Singh, if your lordship will kindly come to paragraph 7, my lord. Paragraph 7 to 9 are relevant, my lord. Within Dinesh Kumar, my lord. Paragraph 21 to 23, my lord.
Paragraph
21 to 23, my lord. Here, my lord, Niranjan Singh has been affirmed by the Honorable Supreme Court. So then, Directorate of Enforcement versus Subhash Sharma. Here also same issue was there, my lord, from para 4 to para 6, my lord. Ordinate bench is, my lord, relying on these three judgments, my lord. First is Kiran Singha, my lord. Here, your lordship. Paragraph 13 onward.
Okay, Mr. Sharma, when he was arrested?
My lord,
But,
because
yeah, I have not remembered the decision of the Supreme Court. In one of the decision, it is stated that time of apprehension may not be the time of arrest.
My lord, I'm not aware of the judgment.
There is one judgment.
My lord, time of arrest, my lord, 10 PM. Date 7/7. My lord, seizure was made 12:06 PM.
If we count that 24 hours from 10 PM on 7/7/2026, then it is.
Then it is okay.
Okay.
It is okay. But if your lordship sees the time from which he was taken into custody, which as per the FIR, it is very clear. At 1 PM, he was taken into custody. At 1:50.
No, what is the exact language used in the FIR?
My lord will kindly see, my lord. I will read, my lord. Page 13, my lord. Subsequently, the police team conducted thorough search of the house premises in the presence of the independent witness while strictly complying with the provisions of so-and-so sections. During search, found huge quantity stock of identical dry ganja, which are kept under the bed secretly in a room and in an adjacent room. Whole procedure was videographed in e-saksho application. The NDPS suspected to be ganja was packed in 3 plastic sacks marked as so-and-so in presence of above noted witnesses. I weighed the same in front of the witnesses using weighing machine, and the total weight of the ganja is found to be 37.94 kg in 3 sacks mentioned as so-and-so, so-and-so, so-and-so. I have seized the ganja as per seizure list from the possession of the accused person and sealed with lock and obtained signature of witnesses and accused person on seizure list as well as seal packets. After completion of all formalities, we departed from the PO at 1 PM and came to police station at 1:50 PM on 7/7/26 along with the seized items and above mentioned apprehended person. So I have already been apprehended, my lord.
No, whether apprehended person and arrested person is the same thing.
My lord, if the judgments, my lord, I'm relying upon, my lord. The question was when the person is taken into custody by the police, whether there is a formal arrest or not. Supreme Court has
No,
made a
here it is not mentioned that they have taken him into custody.
My lord, if they have apprehended me, my lord, and they have the language is clear, they have apprehended me and they have taken me into police custody, police station, my lord. So I am in their custody, my lord. There can be no other way of interpreting this line, my lord. they have taken me, apprehended me and taken me to the police station, my lord.
Mm.
So at this stage, my lord, I am in their custody, my lord. And that is what, my lord, both Narinder Singh and Dinesh Kumar also says, my lord. That, my lord, semantic differences between, my lord, will not take away the right of the person, my lord. If he is in the control of the police, his movement is curtailed, my lord, then he'll be deemed to be in custody, my lord.
Okay. So, now you hand over the case.
My lord.
Supplementary list, item number 38.
Deeply obliged.
May I please, Lordship? Lordship, the petitioner is behind the bar, Lordship. Today is 109 days, Lordship. Allegation is under section 87 and FOXO 4. Lordship, the kindly peruse the page number 24, Lordship, the deposition of victim, Lordship. Lordship, we are not denying the under section 2D of FOXO Act that 2D section defines child below 18 years. Deposition is not valid, but we can understand by the deposition.
5 days has gone, my lord. 5 days.
5 days.
Yes, my lord. Today is the 6 days. Give them last chance, my lord. Oh. No, no, no.
Heard Ms. Kedevil, learned counsel for the applicant, and also heard Mr. Borthakur, learned additional people for the state respondent. Mr. Borthakur submits that he has not received the case aid. But Ms. Devi has pointed it out that as many as 5 days have been given to the prosecution side to produce the case aid. And as such, a last opportunity may be given to the prosecution side to produce the case aid. Accordingly, it is provided that Mr. Borthakur shall produce the case aid before this court on 20? On my lord. 24? 24. 24th of August.
Yes.
August 27, my lord, or 28?
28.
Yes, ma'am.
Okay, all right. In the event of failing to produce the case diary on that day, the court will proceed to hear and dispose of this petition without case diary.
Obliged.
28.
My lord,
Yes.
item number 28, my lord, earlier also IO has, but today, my lord, verbally they have stated that notice served, because on earlier occasion I have taken 2 days time, my lord. As per, but due to some, my lord, their transmission, they have somewhere, my lord, that service report he misplaced, my lord, as per for which, my lord, he could, but otherwise he, according to him, my lord, he has served the, my lord, notice to the victim, my lord.
Okay, then let there be amicus. Heard. Mr. Amel, learned counsel for the applicant. Mr. Borthakur, learned additional PP for the state respondent. Mr. Borthakur, learned additional PP applies this court that as per his instruction, notice upon the respondent number 2 was served, but the service report has been misplaced.
Yes, ma'am.
Misplaced. Accordingly, taking note of the submission of learned counsel for the learned additional PP, this court is inclined to engage Sri Masum Alam as the amicus to represent the respondent number 2. Rest shall reflect the name of Mr. Masum Alam in the cause list and also furnish the relevant papers well in advance and list the matter on when?
Next week.
Next week. 30% বেশি দেরি হয়ে যাবে। আগতে 26?
Yes.
26. You have received the case diary?
Yes, case diary received.
Till then, case diary will be retained.
29 and 36.
Made fees on also. 2 years bail, madam. Item number 29. Case diary was called for, madam.
29 and 36, my lord, same cases.
Madam, the FIR is at page 16, madam.
Petitioners are different,
Petitioners are different. Here,
but
madam.
arising out of the same FIR.
One item number 36, he is the husband of the deceased, my lord.
36 I am appearing, but in this case, my lord, I am not in the engaged counsel lordship, even though in the morning time mentioned, senior counsel senior Mr. Ali, his junior is mentioned the morning time, but Mr. Ali is immediately admitted in hospital, but he's telephoned to me, so just in this case, adjourn for today. In the meantime, sir, lordship, Monday will be taken in this case, your lordship.
Monday.
And CD may be detained. Item number 36.
Mr. Ali was for
Item number
36.
36.
36.
Now, can we not take up this matter today? 29?
And then together, my lord, on Monday.
Monday?
Monday.
Okay. As agreed by learned advocates of both the parties, this is a list this item along with item number 36 on Monday.
Diary to be written. Diary to be written till.
Okay. Till then, case diary will be retained.
I'm
Being at number 10.
My lord, regarding Zimma of cattle when there is cruelty, my lord. My lord, kindly peruse the book, my lord. My lord is holding the book, my lord. No, origin book. My lord, in that book, there is originally there is 2 words except, my lord. In 11:5, the word in 5th line in that book shown as omitted, star mark has been given, and there is another word except. Now, my lord, kindly peruse the other book, my lord. I have the notification only for clearance. I have flag mark, my lord. Madam, kindly peruse the flag mark. Same paragraph, my lord may see vehicle convenience in 5, my lord. 5. Vehicle convenience except cattle, that is there. And another in below portion there is star mark. And that star mark except word has been omitted, my lord. So there is difference in the book, my lord. Book. So books are comes after the notification, my lord. So this is the Gazette notification, Assam Cattle Preservation Act, and this is the amendment. My lord, kindly peruse, everything will be all right, my lord. It is crystal clear, my lord. Or some author, my lord, may done mistake in the book. My lord may peruse the first. I have flag mark in the notification, Gazette notification, my lord. First Gazette notification. In that Gazette notification, my lord, I am reading 11:5, my lord. 11:5, my lord. On receipt of report, the judicial magistrate first class may, on his being satisfied that there is enough material to presume that a prima facie offence under this act has been committed or intended to be committed, release the seized materials, including vehicle convenience, except cattle, on furnishing a bank guarantee equal to the value of the materials or vehicle convenience, except to the satisfaction of the court, pending disposal of the criminal proceeding instituted in respect of the alleged offence. Now, my lord, kindly peruse the amended notification. That is flag mark. 2 pages notification. In the amended notification, my lord, that para for, my lord, come to 4 Roman 1. In subsection 5, in 8th line, in between the word vehicle convenience and 2, the word except shall be omitted. Now, first except is, my lord, in between vehicle convenience and cattle, except cattle. And second except is, my lord, vehicle convenience and 2. So in the 8th line, my lord, again peruse the first notification. There is in 2 except word, one is in the 5th line, one is in the 8th line. So in the 8th line, vehicle convenience and 2, that except has been omitted, my lord. So in our book, my lord, in the small book, that is clearly mentioned, my lord, the second it is omitted. But some author, my lord, may done mistake, and that book has been published. In that book, first is, so I have produced the, my lord, gazette notification. Gazette notification has come, my lord, first. Now in the similar line, my lord, our High Court, my lord, there are Supreme Court judgments also, my lord, but our High Court recently, my lord, on coordinate bench, on, my lord, judgment passed on 13th of this month, my lord. My lord, kindly peruse para 10 of this judgment. Confusion on because of these books, my lord. But gazette notification has come first. Subsequently, someone has published. Now there are many authors have published many books, my lord. So there are mistakes in the books. And in our books, my lord, in small books, there is no mistakes, my lord. In our book, it is as per the notification. So confusion because of these books, my lord. First word is, my lord, vehicle convenience except cattle. So in between the word convenience and cattle. And second word is vehicle convenience 2, except 2. So it is clearly mentioned that word in between vehicle convenience and 2 in the 8th line. So my lord, may count in the first notification, there is a 2 word except, 1 except in the 5th line, 1 except in the 8th line. So 8th line except has been omitted, my lord. The 5th line, it is there, my lord. In this judgment, my lord, para 10, my lord, kindly. I am not going by the para. Being a special of the provision of the said act would prevail, reverting to the provision of subsection 5(11) of the act, which has been reproduced herein above. It is clear as daylight that magistrate has no power to release the seized cattle to the owner pending disposal of the criminal proceeding. And this present case has been registered, my lord, in both Assam Cattle Preservation as well as the cruelty to animals act, my lord. And as per the rules of animal cruelty to animals act, my lord, no goods carrying vehicle can carry not more than 6. In a Jodha, my lord, this vehicle carrying 8 numbers of cattle, cruelty has come, my lord. So it will be decided by the trial court. Till the decision of the trial court cannot be given zimma to the owner, my lord.
Yes, Mr. Bora.
My lord, in fact, my learned friend, my lord, what is referring to, my lord, 11.5, my lord. In fact, this position, my lord, may and shall, that has been clarified by this court, my lord. In fact, if there is any, my lord, insertion of word except, that is not relevant for the purpose to decide, my lord, the interim custody, my lord. That is my understanding. And your lordship will, my lord, that is the clarification by this court, my lord, that may and, my lord, shall. Because only, my lord, they are referring to, my lord, the word except, my lord. So for the books are concerned, my lord. So may is not interfered with by any, my lord, gazette notification or any other by this court, my lord. It remains, my lord. So may and, my lord, shall, my lord, the difference has been, my lord, clarified by this court that it is permissible. So that is the discretion with the magistrate, my lord. So that has been, my lord, somewhere it is not, my lord, applied to incorrect, my lord, terms, my lord. So that has been, this is clarified by this court, my lord. And in fact, my lord, in addition to that, my lord, that cruelty to animal act 1960, the 35(2), that has been also observed in this order by your lordship. And this court, my lord, while releasing this, my lord, cartels, my lord, in interim custody, my lord. So both the, my lord, provisions of law has been clarified in this case, my lord. So may and, my lord, there is only, my lord, distinction is may and shall. That has been, my lord, clarified.
Yes.
So in their gazette notification, may is there, my lord. May is remaining there in the gazette notification, except is clarified only. If my learned friend is referring
May is there,
to, my lord, the books, my lord, different books, my lord. If I may say, my lord, this is clarification has been there already, my lord, may and shall. If the learned trial court is, my lord, vested with the, my lord, power to, my lord, release or not, this is to be confined, my lord. And that has been clarified, your lordships. There is an order by your lordships, my lord, that it's not may, it can be, my lord, interpreted like, my lord, shall.
Maybe, my lord, I may be wrong, my lord, but at that point of time, my lord, this
Para 11, my lord. Your
argument
lordship's
made
order,
on
my
the
lord.
place, my lord. That
It is
may is
clarified.
regarding, my lord, may is regarding, my lord, may release the vehicle, may not release the vehicle. Regarding may, my lord, there is bar in the regarding cattle, my lord.
May
there
is not
certain
bar,
bar.
man.
No, yes.
Para 11, man.
Yes.
And there is, my
Okay, now the dispute is in respect of color of the cattle.
Six cattle, man.
So, trial court will consider the same in accordance with the color described in the Caesar memo.
Yes.
And they have to release the same.
Yes.
What to do?
Malat, but regarding Malat, if Malat,
in fact, my lord, trial court has already decided, my lord, rejecting my application, my lord. My lord, on the basis of the Kala, my lord. In fact, my lord, Kala, my lord, that
Now direction will be as per Caesar memo.
Lordship.
As per Caesar memo.
Malat, one pair from my side, Malat, that is there. But if yes, regarding color, that is there. But if there is cruelty, Malat, and it is registered under Assam Cattle Preservation Act, till the decision of the trial court, who will get the Malat?
Interim custody.
Interim custody cannot be given to the owner if there is cruelty. Malat, to that aspect, Malat, I am placing another judgment from this honorable court, Malat. It's
cruelty is the, my lord, trial part, my lord.
Yes,
cruelty cannot be
trial,
decided at this stage, my lord. It's a spacious vehicle, my lord.
My lord, I am submitting to the lordship, but I am reading before that, my lord. If there is a cruelty, my lord, on complying to the repeated the question whether petitioner Meher Banu is entitled to the custody of the said cattle would be decided based upon the decision at the trial. Here, my lord, in this particular case, the learned trial court has rejected. Thereafter, a criminal revision petition has come. High Court has rejected. And thereafter, they went to the Honorable Supreme Court. Honorable Supreme Court.
Here the trial court has not considered that aspect. Trial court has only considered the color of the cattle.
Yes.
And thereafter dismiss the petition.
Yes, that is there, Malad, but my prayer.
That order is being challenged here.
Malad, yes, that is there, Malad, but then only my prayer is that, Malad, when it is registered in the Assam Cattle Preservation Act, when there is a bar, Malad, and
the bar is not absolute, bar is there, it is may.
May, Malad, for my satisfaction, may I read again, Malad?
No, not necessarily.
Malad,
Don't
may
consume the time of the court.
May is regarding, Malad, may kindly period before passing, Malad, kindly.
May is regarding?
May is regarding the vehicle. May release the vehicle. May release convenience except vehicle, except cattle. So regarding cattle, there is a bar, Malad. So may is regarding the vehicle. Vehicle may give Zimma, may not give if satisfied. Regarding cattle, there is bar except cattle. That word has been there, Malad, and that is not omitted. I placed the Malad gazette notification. Notification has come earlier, Malad. Some author may have done mistake in the books, Malad.
Okay, we will pass the order.
And Malad, kindly this Meher Banu judgment and Honorable Supreme Court, Malad rejected Meher Banu.
That is, Malad, reflected your lordship's order, man. That is your lordship's order. That is all the facts is, Malad, included.
Yes. Kindly.
Okay. Next item.
I'm deeply obliged.
May it please, Lord. Lord, this matter, Lord, is seeking quashing of a DV case, Lord, proceedings of a DV case, the matrimonial dispute, Lord. There are certain other cases between the parties, my lord, which has already been amicably settled. This
We have filed case 13 lawsuit. Annex of 1.
Okay, today we will admit the appeal. Let notice go. Hard miss.
Peace of your lordship.
Learned counsel for the appellant.
Also legal aid counsel as.
Legal aid counsel. Okay, learned legal aid counsel for the appellant. This appeal under section 415 of the BNS 2023 is directed against the judgment dated 8/6/2026 passed by the learned additional session judge Bizney in session case number 189 of 2018, whereby the learned additional session judge Bizney has convicted the appellant under section 304 part 2 IPC and sentenced him to suffer rigorous imprisonment for 5 years and also to pay a fine of ₹10,000 with a default stipulation. Peruse the memo of appeal and the grounds mentioned therein. Then also peruse the impugned judgment dated 8/6/2026. Admit, issue notice to the respondent returnable in 4 weeks. However, no formal notice is required to be issued to the respondent since Ms. Hoya learned additional PP cum senior advocate assisted by Ms. So entered appearance and received notice. However, extra copy of the memo of appeal they furnished to her during the course of the day. Justice will call for the record from the learned trial court and list the matter after 4 weeks. Is there any IA?
Yes, lordship, for suspension of the judgment, lordship.
Notice may go, man.
Yes, issue notice. List after 4 weeks. But here state is the only party.
After receipt of TCR,
List this IA on when after 2 weeks for consideration.
17.
Obliged. May I please, your lordship? Lordship, the petition appellant has been convicted under section 10 of the POCSO Act for
Let this scan copy of the evidence to my call for minute.
Perhaps evidence not started because stay order is there.
Stay order is there?
Yes, stay order is there.
Statement.
Part Mr. Ahmed, learned counsel for the petitioner. Ms. Moya, learned additional PP for the state respondent, and Mr. Biswas for the respondent number 2. Mr. Ahmed, learned counsel for the petitioner submits that in order to adjudicate the issue raised in this petition, perusal of the record and the case diary will be required, but the same has not yet been called for. And accordingly, he submits that the case diary along with the scanned copy of the record may be called for. Accordingly, it is provided that Justice shall call for the scanned copy of the record along with the scanned copy of the case diary, fixing the matter on. From where it will come?
From Sribhumi.
Sribhumi.
4 weeks. 4 weeks.
22nd September.
22nd of September. Till then, interim order pass earlier shall continue.
Obliged.
Supplementary, agenda number 37.
Lordship, the engaged counsel is on leg, so currently the matter may be fixed at 2 p.m.
No, 2 p.m. we cannot. Some other matters are there
and it fixes.
at 2 p.m. On the other day also same thing happened.
Yes,
Today
Your
also
Lordship, it got closed actually.
Today and tomorrow at 2 p.m. not possible. Some other matters are there.
Friday.
Solicitor General of India will be appearing in one matter of Arunachal Pradesh. So
On Friday then.
Friday.
Oh, I don't know, whatever is the
Friday.
submission.
Monday, next Monday.
Monday.
Monday, Lordship, Friday,
Friday not possible. A lot of matters already fixed.
তোমালোকে সদায় দেৰি কৰে সেইদিনাখনো পিছত আহিছে
List this matter on Monday. Monday.
Before,
Let your Lordship.
timing at the number 38.
সেইদিনাখন পৰীক্ষাৰ পিছত আহিছে
Wait, something.